Look, are you staring at a literal mountain of case briefs right now, just totally overwhelmed, feeling like you're drowning in 1L contracts? Trust me, you are absolutely not alone. But here's the really good news. You don't actually need to memorize every single word of every single case to ace your final exam. You just need a system. Welcome to this explainer. Think of this as your tactical briefing. Today, we're going to conquer those time-sensitive final exams by building the ultimate contracts attack outline.
Our absolute mission today is to take that dense, intimidating body of case law and transform it into a super streamlined, high-scoring exam strategy. Because let's be real, when you sit down in that exam room, the clock is your absolute biggest enemy. You literally do not have time to sit there and ponder the philosophical origins of the law, right? You need a structured, mechanical approach so you can spot issues instantly and just rack up those points. And that is exactly the tactical system we're going to build together today.
Okay, let's dive into this. Here is our precise roadmap for attacking absolutely any contract fact pattern your professor throws your way. We're going to start with the gateway law, move right through formation and defenses, tackle performance and breach, look at remedies, and finally, lock in a strategy for fast IRAC essay writing. Now, this linear timeline, it is the fundamental secret to contract analysis. It perfectly mirrors the chronological life cycle of an actual contract. And honestly, this is exactly how you have to analyze an exam prompt. Like, you would never start by arguing about damages if you haven't even proven a contract was formed in the first place, right? By following this exact chronological timeline, you make sure you never miss a step. Plus, it naturally organizes your essay exactly the way your professor's grading rubric is organized. It's a total win-win. So, step 1, the gateway law, determining the rulebook, because before you even analyze a single word of an agreement, you absolutely have to figure out which legal rulebook applies to the facts.
It's actually kind of wild how strictly contract law divides the world. On one side, you've got UCC Article 2. This governs the sale of goods, so things that are tangible and movable. Think computers, cars, or, I don't know, a massive order of sandwiches. On the other side, we have the common law. That's basically the default for everything else. Services, real estate, employment contracts, the whole shebang. But you might be wondering, what if your exam prompt has both, like say a contract to buy paint and hire a painter? Well, for those hybrid contracts, you apply the predominant purpose test. You just step back and ask, what is the absolute essence of this transaction? Is it the goods or the service? Whichever one is the primary purpose, well, that rulebook governs the entire contract.
All right, once we know our rulebook, we transition right into step 2, formation, building the contract through mutual assent and consideration. This is where we look at the facts and figure out if a legally enforceable promise was actually created. So the crucial point is, you need a bulletproof way to remember the steps of formation instantly, especially when you're under pressure. Enter our first powerful and, okay, admittedly super weird, mnemonic toolkit. Good frogs make outstanding apple cider donuts, or GFMOACD. Look, law school is traumatic enough we might as well use some fun mental anchors, right? If you just quickly scribble this acronym at the very top of your scratch paper, boom, you have your entire formation outline ready to go.
Let's rapid fire through these elements. G is governing law, which we just nailed down. F stands for the baseline rule of formation. Now M is mutual assent, which is really just the combination of an O for offer and an A for acceptance. And remember, a valid offer requires objective intent and definite terms. Under common law, that means you absolutely need the parties, the subject, the quantity, and the price. But under the UCC, you just need the parties, subject, and quantity. The court can actually just fill in the price for you. Then you add in C for consideration. That's your bargained for exchange. And finally, you check for D for defenses.
And speaking of defenses, that brings us to step 3. Defenses, invalidating the contract through structural bars to enforcement. Because once a contract looks perfectly formed on your exam, you can't just stop and celebrate. You have to immediately pivot and see if it can be broken. To catch every single sneaky trick your professor hides in that prompt, you're going to use the acronym LDUMSI. Now don't panic, it's just a checklist. You're simply scanning the facts for a lack of capacity, like say a minor trying to make a deal. You're looking for duress, like an improper physical threat. You check for undue influence in a trusting relationship, mutual or unilateral mistake, unconscientiality, and misrepresentation of facts. And crucially, absolutely crucially, the statute of frauds, meaning agreements that literally have to be in writing. The statute of frauds actually has its own little sub-checklist, my legs: marriage, year plus, land, executor, goods over $500, and suretyship.
And finally, just check for illegality. If you run this exact checklist, I promise, no defense is going to slip past you. Moving right along our timeline, we hit step 4, performance and breach, standards and supervening events. If the contract is formed and there are 0 valid defenses, we move into the really messy part, figuring out what happens when things actually go wrong. To lay out this analysis super fast, we deploy another mnemonic. Plump cows always roam down bumpy roads, or PCARDBR. First up, evaluate P for performance. Basically, are we using the common law standard of substantial performance or the UCC's incredibly strict perfect tender rule? Next, check for C for conditions that might trigger or excuse a duty. Keep an eye out for A, anticipatory repudiation, which is just when a party backs out early. Then figure out who bears the R for risk of loss. See if performance is D for discharged by something crazy like impossibility. Determine if there's a material or minor B for breach, which of course finally leads us to R for remedies. And this brilliantly illustrates our point. Let's look at the famous case of Burger King versus family dining. So, family dining had this exclusive 90-year territorial agreement, but only provided they built restaurants at a really strict specific rate. Well, they were late building a few locations, and Burger King tried to just terminate the entire contract based on that strict condition. But the court actually stepped in. They ruled that rigidly enforcing that development condition would result in an extreme forfeiture for family dining, especially since they take it on all the early risks. It perfectly shows that courts won't always enforce a condition if it leads to a massively disproportionate penalty. Which brings us to the ultimate consequence, step 5, remedies, fixing the breach and calculating the recovery. You've proven a breach happened. Now you have to establish what the plaintiff can actually get out of it. The absolute easiest way to categorize your remedies is MEM, money erases misery. This just reminds you to check for M, monetary damages, which is the default expectation, trying to put the party exactly where they would be if the contract was actually fulfilled. E stands for equitable relief, like specific performance. Now, that is an entirely different beast, and it's only used when monetary damages just won't cut it, like if you're dealing with a totally unique piece of real estate. And the final M is mitigation. You must always note whether the non-breaching party took reasonable steps to minimize their own losses. Don't forget that one. Now, when you're actually calculating those standard monetary damages, I want you to visually stack this acronym in your mind. MPACADLC. Yes, I know it is an absolute mouthful. It's ridiculous, but having this exact list sitting on your scratch paper, that is literally what separates an A from a B on a law school exam. It forces you to remember the mitigation duty, the fact that punitive damages and emotional distress are generally excluded in contract law, the American rule for attorney fees, and the specific standards for construction or employment contracts. If you run through this specific list, you are showing your professor you know exactly how to calculate the check at the end of the lawsuit. All right, now for the final piece of the puzzle, step 6, condensing rules for fast IRAC, turning concepts into checklists. We've talked a lot about legal theory, but now we have to weaponize it. You really have to adopt what I call checklist thinking. When you're under the intense pressure of a timed exam, you literally cannot write dense, meandering paragraphs of case law. You just have to execute. Step 1, spot the issue by simply walking down that chronological timeline we built. Step 2, deploy your mnemonic checklist so you can generate your rule statements instantly. So for example, if the issue is an offer, you immediately write down your checklist. Intent plus definite terms plus communication. Boom. Step 3, execute the IRAC structure. Facts, issue, rule, application, and conclusion. Keep it tight, keep it moving. Let's move to and see how this builds your actual application section. Listen, the biggest mistake students make here is stating the rule and then just blindly stating a conclusion. You have to connect them. Use the because rule. When you write your analysis, physically write out the word because. Frame it exactly like this. The requirement for a valid offer is met because the fact pattern states the defendant specified a price of $500. Do you see what that does? It forces you to directly connect the abstract legal theory to the exam's exact, specific facts. Seriously, it is the single fastest way to pick up analysis points. So here's the final question you really have to ask yourself today. Are you going to let dense case law and hundreds of pages of reading defeat you in that exam room? Or will you use this structured, tactical attack outline to take complete control of your finals? I think we both know the answer. By following the chronological lifecycle of a contract, deploying your mnemonics, and rigidly applying your checklists, you can dissect absolutely any fact pattern with blazing speed and total precision. You've got this. Get out there, build your outline, and go completely crush that exam.